Hi, I'm Debbie Moraes, and once again, this is Legal Matters, the program that's been designed to address the critical, contentious, timely issues that are facing businesses and consumers today, legal information, practical solutions, and straight talk about a wide variety of topics that will affect your home and your work life. We'll get help and guidance, as we usually do, from our lawyers from Bazar, Grasso law firm in East Providence, Jackie Grasso and David Bazar.
Debbie.
Once again, as we think about addressing some of the timely topics today, landlords and tenants, and no matter which one you are, you have rights and you have responsibilities. Your landlord might want to evict you as the tenant. You as the tenant might want to withhold some of your payment because perhaps the landlord didn't do right by you. Laws exist to protect both and to benefit both, and they differ from state to state. So today we'll have our attorneys address that. Over the past year, 2 years, we've had agonizing amounts of housing foreclosures and house losses. That seems to have abated, and so the economic crisis has been just a little bit made easier for most people. However, the relationships and issues that are affecting the owners of commercial property or residential properties and the tenants, those who are renting from them, those kinds of issues and contentious issues sometimes continue. We wanted to hear from the lawyers about what the most egregious one is first, and that certainly is the issue about eviction. So, Jackie, David, under what circumstances does a landlord actually get to do that?
Well, you have to start out by determining whether or not there's a lease. If there's a written lease and they default on the terms of the lease, then that gives the landlord a right to evict. If there's not a written lease, same thing, except you're not locked into a certain time period. So if you don't have something in writing, it's called a periodic tenancy. If your tenant doesn't pay rent or creates havoc on the property, commits a crime, then the landlord can evict. Or, again, if he doesn't want to renew the lease, or if he wants the person on a periodic tenancy to leave within a certain period of time, they have a right to evict. The benefit of having a lease is you are locked into a certain period of time, and more than likely it's 1 year, 6 months to 1 year.
Most people don't rent week to week or month to month.
Month to month actually is probably the most common.
It is.
Because it's how you pay, and most people generally pay at the beginning of a month for that month. So month to month is the most common. And probably the most common reason someone is evicted is for non-payment. And in a residential situation, there's a process that the landlord has to go through for that eviction.
What happens, say, for example, when someone is month to month and they miss a month? That seems like, or maybe they're late for a month. What kind of latitude do you have that's reasonable before you have to, before you'd be inclined to want to evict?
More than likely, the landlord will give you at least a grace period, and that should be in your lease. They may penalize you by charging a late fee, but if they give you a grace period of around 30 days, which is reasonable, then you should be okay. But if you're 60, 90 days past due, then the landlord does have a right to evict.
Right. And by law, what would generally happen is if you're more than 14 days in arrears on your rent, the landlord would send, in a residential situation, a 5-day demand letter that says you're behind in your rent and you have to pay it. Now, if you pay it, that's the end of the story. If you don't, then the landlord has the right to go ahead with an eviction for non-payment of rent. And even at that point, if you come into court, because you'll get served with a summons and a complaint with a court date on it, if you come to court with the payment and bring everything up to date the first time, you get a bite at the apple, then the eviction will be dismissed.
It's similar in Massachusetts as well. In order to begin an eviction for non-payment of rent, they have to send a 14-day notice to quit to the tenant and giving them that amount of time, a certain amount of time to catch up on the rent. If not, then you go to the next stage, which would be you have to go to housing court in the county where the apartment is, and then file a complaint for an eviction in housing court, have that served on the tenant. And again, as David said, tenant can go to court and work out a payment arrangement with the landlord. So it's not, all the time. It doesn't happen all the time that you would get evicted, but it might be a way of working out a payment plan.
Staying with the residential tenant for the moment, suppose he feels that he shouldn't have to be paying the rent because the landlord didn't make a necessary repair, maybe not a critical repair, although we should talk about that separately, but the landlord promised to fix some stove or whatever. Does the tenant have the right to withhold payment and say, I'm just not going to until you keep your end of the bargain?
You do have a right to withhold a payment, but you have to make sure you put that notice in writing to your landlord. I always tell people, keep the money in a separate account and make sure that you don't use it for anything but rent, but you do have to send a notice to the landlord informing the landlord as to why you're withholding the rent. And if the landlord does the repair, then you have to release the money. If it's an emergency repair, like lack of heat or anything like that, well, you still have a right to withhold the rent, but the landlord does have to get back to you within a reasonable amount of time. Heat during the winter would be 24 hours immediately. Or if a landlord has to repair a door, getting back in 24 hours is not considered reasonable. It's just, a reasonable amount of time there would probably be about 30 days or a couple weeks.
I know that both you and you have always stressed the importance of documentation, and I assume that the landlord would be the one who would be having the lease, and he has his list of things that he wants done and covered and what he doesn't cover. What kind of plan should the would-be tenant have to make sure that he's protected?
And when you're asking that question, are you talking about when you enter into a lease? Or
First, and then when there are other problems that require documentation, such as Jackie was referring.
Right. So when you enter into a lease, it's a contract. And like any other contract, you need to make sure all of the terms of the contract are contained in the lease. So if, for instance, you want to have a pet on the property, spell it out, that it's all right, it's legal for me to have my dog on the property. If it's a question about who's going to maintain the property or shovel the snow or those types of things, spell it out. So those are all the things that some of the things you need to go through a checklist of in determining who's going to be responsible for different things, the landlord or the tenant.
May I give you a couple of other suggestions or questions that have come up? For example, you wouldn't necessarily know whether or not the tenant, or maybe the tenant himself didn't know at the time, he decides that he wants to have a garden, and on that property there certainly is more than grass, there's enough space. He wants to start shoveling and digging and put in some reasonable, I don't mean unearth every square foot of soil there, but if he wants to suddenly have a garden, should that have been something that had to have been listed in a lease either by the tenant, by the landlord, or what's required?
Well, if it's something you knew about in advance, then you certainly would want to spell that out. Now, it would, of course, be different if you're talking about someone who's renting a single-family residential property as opposed to an apartment in a large complex. Obviously, in the large complex, there's a lot of people who are using the common areas, and you can't use the common area to the extent that you want when it's to the exclusion of other people. But if it's a single-family residential property with a lot of land in a suburban or rural area, what I would suggest is you contact your landlord and say, this is what I want to do, and have them agree, and if they do agree, get it in writing.
Yeah, definitely get it in writing. Yeah.
So both of them would have to put that in writing?
Oh, yeah, definitely. It's always better to have it in writing, because if there is a fallout between the tenant and the landlord, it's going to be a he said, she said. So it's better to have something documented than not.
When the landlord presents, or the would-be landlord presents a contract to that tenant, do you think that the tenant needs to have a lawyer review it, or is that something that they can pretty safely do on their own?
I think a tenant can do it on their own. I mean, to have a tenant, it depends on the type of lease.
Right.
If it's a commercial lease, then absolutely I would agree, because it is very difficult to understand.
Complex.
Yeah, it's a complex. Sometimes they're like 20, 25 pages. And yes, you should get the advice of a lawyer in that situation.
A simple 2 or 3 page residential lease is going to have hopefully language that anybody can understand and read through and understand what your rights and responsibilities are. As Jackie's saying, with a commercial lease, now we're shifting perhaps liability from a landlord to a tenant. Mm-hmm. We're requiring insurance. We're requiring all sorts of different, who's going to pay the taxes, the insurance, those types of things are all things that are subject to negotiation, first of all, and second of all, they can be complex in the language that attorneys use in drafting those documents.
So beware with that.
Correct.
And sticking with the issues about eviction for just another moment, people who have children, people who are disabled, or the elderly, if they have a notice of eviction, because they end up having any one of those statuses, would it make sense that they get more of a pass or some sort of leeway? And what should they do that might be different from the average citizen?
Well, I think they're afforded additional time, so they just can't get out and in a 30-day notice just tell somebody you have to leave. If you have disabled people in the household, they're given additional time.
If it's a non-payment,
Then that's different.
it's different, and you have to pay no matter what, your situation is, unless there's a defense to the payment, as you spoke about earlier. I do think that many judges have hearts and that they will try to get people to work things out a little bit more. If it's Christmas time and we're talking about evicting children from their homes or something like that. But the rules are the rules. So if it's a non-payment situation, you have to follow the same rules.
What about your interest in, if you're the landlord, interest in evicting someone because they have illegal drugs or they're doing some sort of illegal business? Is that a right then to evict someone without saying, I really would like for you to stop peddling pot or whatever?
Not only is it a right, it's important that the landlord do that. It's imperative, because if he does not seek eviction from the tenant, he or she can be liable for the criminal activity that occurs by their tenants, especially if they had knowledge that it was occurring. But yes, again, you look to the lease. Obviously, you're not going to have a term in the lease that says...
Please don't.
Yeah, you can have illegal activity on the property, but if that happens, that is cause for eviction, and you go back to the eviction statute, whether Rhode Island or Massachusetts, comply with that. So in that case, it would be a notice to vacate property, and similar in Rhode Island.
So some leases might have some language that says you're not going to do anything illegal or unlawful.
breach, yeah.
They might also have language that you're not going to violate any of the zoning laws. So if you rent a residential property and you start opening up for commercial business of some type, legal or otherwise, then let's just assume it's legal. You're running a massage parlor out of the house as well as using it as a residential property, and that violates the zoning laws. Well, the landlord can write a letter to you to say you're in breach of the lease, and you have to cure the lease, the breach. And in fact, in the lease, it'll tell you sometimes you have X number of days to cure the breach. And then if you don't, then you can be subject to an eviction.
Okay, and what about the issue about when a landlord can go to visit the property inside and out? What is the landlord's right? What's the tenant's right?
Tenant has a right to privacy, just like anybody else, is as if that tenant owned that property, him or herself. The landlord has a right to visit the property with ample notice and within a reasonable amount of time. The landlord cannot knock on your door today and just expect to get into your house. They have to give you a reasonable amount of time. If it's an emergency, then you still have the, if it's an emergency, the landlord can come in, but he still needs your permission.
Right. When you rent a piece of property, it's as if you own it for that term of time that you're using it. And you have to weigh and balance the landlord's rights to get to the property. For instance, if it's towards the end of the lease, to show it to somebody so that they can rent it out at the end of the lease. If it's an emergency, obviously there's different rules that apply. But when you own a piece of property, you have a right to quiet enjoyment. And when you're renting a piece of property, you still have that right to quiet enjoyment, not to be interfered with by the landlord in your use of the property.
Okay, let's talk about other money issues. So, for example, you know that when you are looking to rent a property, you expect to pay some sort of a deposit, you expect that there might be a security deposit, there might be a first month's rent, last month's rent. What other fees are expected or not expected?
In Massachusetts, it shouldn't go beyond the first month and a security deposit. And in fact, there is a part of the landlord-tenant statute compels the landlord to take the security deposit, put it in a separate bank account, an interest-bearing account, and once a year they have to pay the interest to the tenant. If they don't comply with that, then that gives the tenant a defense should and if they ever become evicted in the property, from the property.
Is that Mass, Rhode Island?
It's Massachusetts is specific. You have to have a separate bank account for your security deposit. I don't think Rhode Island requires that, and they don't require that the landlord pay interest on an annual
Right.
basis.
What Rhode Island requires is at the end of the lease, if you move out, you give the forwarding address to the landlord, and the landlord has, I think it's 30 days, to send you a letter detailing any of the damages that they're withdrawing from the security deposit and returning the rest of the money to you. If they fail to do that, then you're entitled to your money back, and if it's not returned, I believe it's treble damages.
Treble damages in Mass, yep.
In
3 times.
Double or triple in Rhode
I
Island.
believe it's double damages in Rhode Island.
Can the landlord retroactively demand more money for a security deposit? Say the circumstances change. All of a sudden, I decided as a renter I want to own a pit bull, and having a dog wasn't part of the issue in the first place, but I might want to ask permission, but I also, should I expect that I should pay more money?
Well, if there's not a term in the lease for having animals, then that's a breach of contract. That actually gives a right to the landlord to evict the tenant. But asking for more money, if it's not in the lease, I would say you can't retroactively go backwards. If they are going to ask for more money and the tenant agrees to it, again, to protect the landlord, I would get it in writing, yeah, and entitle it supplement to the lease, which was originally dated whenever the person moved
Right.
in.
And to your question as to whether it's reasonable, well, if the dog is on the property and that dog attacks somebody off the property or on the property, and it's done before on the property, the owner of the property can be liable for the damages that the dog does to somebody. So, because the Rhode Island statute talks about the owner or occupier of land is responsible for the damages done by a dog bite. So is it unreasonable? I don't think it's necessarily unreasonable that the landlord has to go out and get more insurance to protect themselves against that, or in the alternative, to require you to name the landlord as a insured on your policy if you have a dog on the property.
Okay, you bring up a good point. Let's talk about insurances. Suppose it's not an issue, David or Jackie, with a dog causing additional concerns of insurance liability. What are the responsibilities of the tenant and the landlord in terms of having insurance? First with residential, then commercial. I'm sure it's different.
Yeah.
Residential, you can get what's called a renter's policy. It's fairly inexpensive, maybe $200 or $300 a year. What that covers, it doesn't cover liability, it only covers loss for whatever, a flood or loss of personal property.
It can provide liability coverage
If it
for
happens
you.
in the apartment.
Right. And you contract with the insurance company for that. Doesn't protect the building itself, just the contents.
As far as the dog is concerned, if it's a pit bull, I think the tenant needs to check with the local city or town ordinances, because there may be a statute that prevents that. There might be also, an ordinance that requires they have a certain policy or license to have, not policy, an insurance policy to have the dog, or a license to have that type of dog. I know to get a renter's policy and ask for a rider with a pit bull, I think it's going to be very difficult, but it may be also expensive.
Should a landlord demand that the renter have insurance, show or give a copy of it or a number of it for his own protection?
With residential properties, the landlord does not have to require that. With commercial properties, it's a must.
Right.
Yeah.
So, and that's exactly right. Generally what happens with a residential property, the landlord's going to have insurance to protect the building from fire or other casualty loss liability. The tenant can get insurance to protect their own belongings and any liability they might be responsible for within the apartment and so forth. Commercial, that's part of what I was talking about earlier, where when you negotiate the terms of the lease, most landlords require their commercial tenants to carry insurance, especially liability insurance, to protect not only the tenant but the landlord for any claims. If someone comes on the property and slips and falls and has a horrendous injury and is going to sue for that, the landlord wants to make sure there's some protection for him or her as well as the tenant.
And they always require that you give them a copy of the policy.
Right.
And I remember when I had a written lease in Seekonk, every single year on my anniversary date, I would get a letter from the landlord requiring a copy of the policy. And if the policy expires, the landlord also wants to be named as a notice party with the insurance company so they know that if your policy lapsed. Again, and that might be a term of breach on a commercial lease as well.
So this is yet another example when you're saying that if it's a commercial lease, you really do need to have a lawyer take a look at it because this
Absolutely.
is not something you'd necessarily anticipate.
Yeah, absolutely.
What about abandonment? Now, if you are a residential renter and you decided to up and leave for whatever reason, you left in the middle of your lease, do you lose security deposit? Are you made to pay the remainder of that rent for the term of the lease? What are your responsibilities?
So if the tenant breaches breaches the lease or breaks the lease and moves out earlier, the tenant is responsible for the remainder term of the lease. However, the landlord has a duty to mitigate damages. So if the tenant leaves in December, the landlord has to quickly find another tenant. If he finds another tenant in April, then that means the original tenant is responsible from the time he or she left up until April. And as far as the security deposit, if the landlord does have a right to keep the security deposit, but for Massachusetts, remember, the security deposit is a damage deposit. You have to have if it's itemized as a damage deposit, you're not supposed to just apply a damage deposit to pass through rent, but they can.
Yeah. And in a commercial situation, oftentimes if someone wants to leave early and they haven't, my advice is always to try to negotiate something before you go. But if you just leave and you're personally liable or the corporation that signed the lease has assets that the landlord can get to, then again, as Jackie said, the landlord has that obligation to mitigate damages, but what happens sometimes is they may have to incur costs such as hiring a broker to rent out the property or advertising, and those are expenses that the landlord may want to assign to the tenant as well.
If the landlord's going to keep a security deposit, then you should have to notify the tenant. It has to be in writing, and if the tenant agrees to apply that deposit to lost a month's rent, then that's fine as well. That's sometimes why they'll get last month's rent as well.
And about that money trail, suppose the renter decides, I really need another stove. It's 3 out of the 4 burners don't work. Now that's not, what did you call it, David, habitability or something?
Well, there's a requirement, an implied warranty of habitability that you can live in the apartment, that it's suitable for its use. Having 3 out of 4 burners probably doesn't breach that warranty.
But
No heat
no
would.
heat, no water.
But it's still enough for the tenant to withhold the rent, send a letter in writing to the landlord. You know, the tenant can also do this. If it's a minor repair, the tenant can actually have it done, have it repaired, pay for it out of his or her pocket, and then deduct it from the rent. But you have to let the landlord know in writing.
And I would give the landlord the opportunity to cure the breach, fix the problem first before you took it upon yourself. If it's not an emergency or some type of situation that you can't live with.
And suppose you have tenants that are less than honest, and they say, well, the burners didn't work, I did fix them, I'm going to deduct $150 from the rent. You're saying it's always important to have documentation. I didn't. I had someone do it.
If you don't have documentation, you're not going to
get
deduct it.
Yeah, you want to be reimbursed from the landlord.
Right.
Simple as that.
For the landlord's protection, is it wise for him or her to give to the tenant, whether it's commercial or residential, a list of suppliers that they work with, vendors who do plumbing repair, water repair, whatever it is, to make sure that the tenant uses them rather than somebody else who might be involved in something that is less
That's
than
not
honest?
unreasonable.
Right.
That's not unreasonable. Sometimes with commercial leases, as a matter of fact, when I had mine, my landlord requested that I use a certain sign company so that my sign would be consistent with
Right.
all the lettering on in the plaza.
Commercially.
Commercially,
Right.
yeah.
In a residential situation with a bigger complex, they oftentimes have a property manager right on site, and you're expected and have to use that property manager to come in and fix whatever problems they are able to fix themselves.
Let's talk a little bit about whether or not they want me as a tenant. They as the landlord and I'm a resident, and they as a landlord if I'm a business. What kind of rights does the landlord have in terms of accepting me? I'm a single parent, I have 4 kids. does that give them a reason to not rent to me?
No, it doesn't. We have fair housing laws in this country, and that would be a violation if a person is refused because of having children. And well, you have to prove that that's why the landlord refused to rent.
How could you prove
Well,
that?
you can't. I mean, landlord can rent really to whoever he wants, but you can't use race, religion,
Sex.
yeah, same thing,
Gender.
as a reason to deny tenancy.
Well, suppose I happen to know that this would-be tenant, 95, subject to falling, may or may not have done it legitimately and likes to sue. What recourse do I have to refuse her the opportunity to live or reside?
Yeah, again, you can't discriminate. Now, there are certain, it's interesting, I think, because there are certain communities that are
Yeah.
over 55 or something like that. And I'm not exactly sure if anyone's ever challenged any of those kind of communities to say, I want to live there till I'm 33. But I know they exist. But generally speaking, it's like we've talked about in employment and other situations, you can't discriminate against somebody because of their any protected class that they would fall into. What a landlord has a right to do is to do a credit check and make sure that you're a good credit risk, and that, because it's sort of to them like they're loaning money to you in the sense that they're expecting payment. So they are able to go out and get a credit check, and if you have poor credit, I would think that that's a ground for them not to rent the property to you.
The other thing that the landlord could do is require names of prior landlords so that they can call for references. And that's not unreasonable. It's not unreasonable to require a credit background check either.
If you're denied access to that property, whether it's residential or commercial, are you, as that would-be tenant, able to ask that landlord why you were denied?
Yes, sure.
Yeah,
Yeah,
you
you-
can
In
ask.
writing?
I don't know that the landlord would respond.
Right.
Yes.
No,
Okay.
If it were my client, you wouldn't get any response back in writing, I'm sure of that.
yeah.
Considering screening is an issue on other background checks, and screenings are popular when it comes to gun control, is it possible to have a screening done prior to renting to someone, a screening fee even,
A screening for what?
to see whether or not I think you're an acceptable candidate?
Like, you're talking about
Living in the place or having your business in there? I'm not sure they want. Apparently, there are some states that really can legitimately, legally have a screening done of their applicants. Is that common here? Is it even?
It almost sounds like a BCI background, or getting a private investigator involved to do a background check.
Yeah,
That's a little
Over the top?
unreasonable. Yeah.
I've never heard of anyone asking for money from a prospective tenant so that they can pay for a background check or
No,
whatever.
that's unreasonable.
Now, they could ask you to sign forms to allow them to do that, and you can decide whether or not you want to sign those forms. But I've never heard of anyone saying, pay me so I can go out and do
Maybe
this.
if it's a commercial lease and you're leasing from the federal government,
Right,
maybe it's
for
reasonable
sure.
to have a background check or a similar screening, whatever.
They certainly seem to get more leeway than most of us. Well, we've certainly covered quite a few topics for landlords and tenants. We hope that that's been helpful to you. We once again want to thank attorneys Jacqueline Grasso and David Bazar from Odette Bazar Cordero Grasso Law Firm in East Providence. Thank you for tuning in. Stay tuned. Our discussion of legal matters continues.